everyone. Welcome to this very special session of our class where we have Alyssa Leader, who is a recent law school graduate, recent as in this weekend, and who's written and researched on the issue of SLAPP, SLAPPs, or strategic lawsuits against public participation, particularly as concerns allegations of sexual misconduct, general sex pestery, or bad sex stuff. Her article, A Slap in the Face of Free Speech, and I'm gonna probably get the subtitle a little bit wrong, but oh shit, I'm not gonna get it at all. Alyssa, can you give us the subtitle?
Honestly, I should be able to, and I don't even know if I know it, but I think it's protecting survivors' rights to speak up in the Me Too era, or something to that effect.
Great. We're both obviously consummate professionals here. So Alyssa's article does, I think, the best job of anything out there of surveying the national trends in laws designed to prevent a certain kind of abuse of the legal system, using these kinds of lawsuits, SLAPPs, to silence speech that people don't like. In the Me Too era, this has become a more common tactic, especially when you have the kind of mass outings of people who have historic records of engaging in sexual abuse, or just mild being a shitty person around sex. I think the way we're going to do this is Alyssa and I are going to talk for a bit. We're going to talk about her article, and we're going to talk about a specific case that there's a transcript of the biggest hearing in the case online that I asked you guys to skim. And we're going to talk a little bit more about that case as a lens to the broader picture of why anti-SLAPP legislation fits into the themes of this class as concerns kind of the interaction between women's rights and the legal system. So the place I'd like to start is just having Alyssa introduce herself. So Alyssa, how did you end up in law school, and how did you end up interested in this topic?
Okay, so that's a big question. So first of all, thank you everybody for letting me join you today. You all have spent a whole semester, I guess, at this point, or you got on a quarter system semester with Professor
We're
Green.
on semesters, and we're in the last week now.
Okay.
It's been a very fragmented and disrupted semester. So I'm very glad we get to do this kind of big thing at the end that at least will be fun. And we'll cover a lot of what I think is important about the class, even though if we haven't gotten to do the same kind of study that we would do in a non-pandemic.
Right, I can relate. As Professor Green mentioned, yeah, I just finished law school, so I did the whole Zoom university pandemic school thing as well. So I just appreciate that you all are here because that in and of itself is huge, and appreciate so much Professor Green inviting me to join you. You've been in their class for a semester, so you know that they're brilliant, absolutely incredible work that I admire more than I know how to say. So when they asked me to join you, I of course was like, oh my God, like, yes. So in terms of my background, how I ended up in law school is kind of a long and winding journey. I knew kind of from the time that I was an undergrad that I wanted to do, I always say, like, I want to do helping jobs. And so I knew I wanted to help folks. But my particular journey to law school actually kind of started when, as an undergraduate, I experienced sexual violence and sexual harassment. And I went through like a whole university process and was involved in like several processes actually in the legal system. And the processes were just like so giant, so impossible to navigate, didn't fit what I needed or what I wanted at the time, and were largely unhelpful. I was really lucky that I was able to connect with an attorney that represented me for free because I didn't have any money. I was 21 and a college student, and was really inspired by the work that he did for me, and started realizing that, if I went to law school, if I became an attorney, that I could do the same sort of stuff for folks. So that was how I got interested in law school, and particularly the intersection of law and gender, and law and like these systemic and gender-based harms that folks experience. So kind of the other and more specific piece of that and how I got interested in this particular issue is when I, was kind of dealing with this situation that I was going through related to my own personal experiences. I, like I said, was 20 or 21. I really had never met an attorney. But one of my first thoughts was, oh my goodness, all these horrible things could happen if I come forward and speak up about my experience and ask for help. And one of the things that just like was a thought that floated through my mind is, the person that harmed me, his dad is an attorney. He's very wealthy. He has a lot of money. He's going to sue me. And I don't even know an attorney. I don't even know what I would do. And I remember that thought like really concerning me and kind of putting me off of coming forward and knowing what to do. It's actually really funny, like based on the work that I've done now, I found some old text messages with a friend the other day where I had said pretty much exactly that. And so at that time, and then as I've continued that work, that moment and that feeling really stuck with me and struck me as a way that the legal system can actually have like this adverse impact of silencing folks who want to come forward when it's abused. And it's still something, oh, sorry, go ahead.
So let's dig into that because I think that segues very neatly into what is a SLAPP. And so to frame this a little bit, the legal system, as we've kind of talked about throughout the class, that there are a lot of stages to a lawsuit, right? And one of the big difficulties in a lot of areas of law is that you can write something that will force somebody to engage in the legal process for a very long time, and it doesn't take a whole lot to get to that. And so what we've talked about before is, right, the life of a case that you file a complaint, there's a motion to dismiss stage where you're not allowed to argue about facts. And then once you get past there, it's years of discovery and very expensive things, traditionally speaking. And only then do you get to argue about facts. And so, Alyssa, if you want to kind of sketch out how that apply, we've talked about that generally, but perhaps if you could frame that in a defamation suit, or why are defamation suits part of what we're talking about here?
Sure. So first of all, y'all like have so much background that I didn't even realize that you had in terms of understanding the different steps of a lawsuit. But the particular kind of case we're talking about right now is a lawsuit that is filed with the intent of abusing the person that's on the other end of it, right? So somebody might file a lawsuit to scare that person into shutting up, or to essentially bankrupt that person, because as you all know, lawsuits are expensive. So as Professor Green mentioned, you can come into court. Anybody can file a lawsuit really about anything. And then the motion to dismiss stage, the burden there is very low, right? So that stage might take 2 or 3 months. But say that the case goes on past that stage, the case could go on for years and years and years and years. So in the context of somebody who's come forward and made an allegation of sexual assault or sexual harassment or other general sex pestery, you might have somebody that is then being sued by their abuser. And now they're stuck like in a legal relationship with their abuser for what could be years and years and years and years. And also in a financial relationship with their abuser because they're paying their attorneys. And then unfortunately, if they lose the case, they might be paying their abuser damages in the lawsuit as well. And so it's just one more tool that these abusers use to control folks and to punish folks who, after the fact, for speaking up.
So let's use that to dig into why defamation in particular, at least historically, has been a useful tool in this arsenal of control, as I think you've described it. Do you want to, or I can, walk through the elements of defamation?
I'll leave it to you.
Okay, I'm going to speak very broadly. I think you might actually know this better than me, despite the fact that I litigate it, because candidly, like a lot of these cases, you end up focusing on one or two of the elements. Others kind of don't matter. But defamation, and we used to make a huge distinction between libel and slander, but that's kind of in the digital age completely collapsed, because it used to be about whether something was written or spoken out loud. And it turns out that certain things that are written are now much more ephemeral than things that are said out loud, right? Like if Alyssa tweets something and it gets 0 likes and 0 retweets, that's actually going to be much harder to find than if I say something really stupid and it turns on like a class video and you guys all share it. Like, the fact that I said it out loud doesn't make that like less meaningful or permanent. So courts have generally recognized, okay, we don't really care about this distinction anymore. So we're all going to just say this is just defamation. Defamation is a public false statement about somebody made with fault, amounting to either actual malice or at least negligence, that causes harm. There are two big categories of defamation, the Latin being per quod and per se. The big difference is that in per quod defamation, you have to prove damages, whereas in per se defamation, the damages are presumed. So I think the place I was trying to steer us is, let's talk about fault. So why is fault a particularly interesting tool or interesting part of this area of law and useful to people who bring the suits?
So I might not be answering exactly the question you're asking, so feel free to interrupt. There is definitely a social and historical context for this, right? There is this larger concern that like women or people who are not men are liars. And particularly when it comes to these allegations of sexual harassment, sexual violence. So that's one piece of it. Legally, the idea is that it's very hard in a lot of ways to prove that a sexual assault or sexual harassment happened. That's why the rates of prosecuting these cases are so low generally in the criminal justice system. It's why people hesitate to come forward. So what happens with one of these lawsuits is it essentially places the survivor of harm on a footing where the plaintiff, who is the abuser, is coming forward and saying, okay, if you don't want to owe me a bunch of money, then you have to prove that I hurt you. And that is difficult to do and really traumatic to do. I don't know if that's exactly what you were getting at, Professor Green.
No, it is. And then I think as concerns kind of the way the legal system works, and I should know better than to ask a question when I have exactly the answer in mind. As concerns the way the system works, it turns out that proving somebody's state of mind, traditionally speaking, is not something you can really do on paper. You have to do it at a trial. And a trial is way at the end of the process, right? That's the most expensive thing to get to in litigation. And so the fact that to win these suits, you have to prove, oh yes, I really believed that this person was a sexual abuser. The people who bring these suits, at least in states that haven't either raised the standard of proof or passed anti-SLAPP laws, which I think is the next place we should go, these things can drag out forever because all they have to do is say, oh, no, I think you didn't believe that. In many contexts. Obviously, I have successfully argued that doesn't work in both of the states I practice in. So let's talk about your paper and the solution. So right, we have this horrible thing, and this thing that where we think the system has broken down and stops serving the people it's meant to serve in a lot of ways. What does your paper have to say to that?
So, big question. So, first of all, you all probably understand that when somebody brings a lawsuit, they're given a lot of leeway by the court. The court tends to believe, for most of the first phases of the lawsuit, they give the person who brought the lawsuit the benefit of the doubt. So we believe that it's possible that this defamation happened, and they're unwilling to dismiss these sorts of things. So again, when that's the case in an abusive lawsuit, that means that a survivor is dragged through for potentially years and years and years until Professor Green said they can get to a trial and start talking about their state of mind. So the idea is that there needs to be something in place that interrupts that, and that kind of flips the script and places the burden on the person bringing a lawsuit in this particular case, not in every lawsuit, but in the case where we might have an abusive lawsuit. It forces them to come out and prove earlier on that, no, this really is a real case. I really do have some elements of defamation here, and there's a good reason that this case should move forward. So in this context, the law that does that is generally kind of broadly called an anti-SLAPP law. It wasn't created specifically to do with sexual assault cases. It was created because these abusive lawsuits were being used much more broadly just to kind of get folks to stop exercising their First Amendment rights. So folks who were passing around environmental petitions or environmental protesters in particular were being targeted with suits, and that's how these anti-SLAPP laws came about. But they are applicable particularly in these situations too. So that is what the paper is about, is kind of the lay of the land in terms of what exists right now with anti-SLAPP law and how well it works. Spoiler, not really great in a lot of places, and what improvements need to be made to actually protect survivors in these situations.
Awesome. So could you walk us through kind of, I know in the paper you outline, I think, 3 different categories of anti-SLAPP law. Could you, either if you want to go through all 3, or if you just want to kind of give a broader picture, how do these laws work, right? Like, what do they do? Sure.
So an anti-SLAPP law generally says to a defendant and says to the plaintiff, the person who brings the case, okay, at the motion to dismiss stage, we are going to make the plaintiff prove a little bit more than we usually do. So like I said before, generally there's a presumption that they actually have a real case. Here, for most anti-SLAPP laws, a defendant will have to show the basics, all the elements of defamation that Professor Green was referring to before. So they'll have to actually show that there's some evidence that a statement was made, that the statement harmed them, that the statement was made publicly. Rather than just saying that those things happened, they might actually have to put out there some evidence that shows it in order for the case not to be dismissed. If they can't do that, then the judge is going to say, well, we're not presuming anymore that you have these good intentions, that this is a real suit, and we want to protect this other person's First Amendment rights, and so we're likely to throw out this case. And usually that can be done if the survivor can show that they are using their First Amendment rights, that they're speaking on a matter of public interest, which sexual violence often is, and that they're speaking publicly, and that's, it's a fair exercise of their rights. And a lot of times, if there's a really good anti-SLAPP law in place, the person who brought the suit, so the abuser who brought the abusive lawsuit, will have to pay the survivor's legal fees, which is huge, because even up to the motion to dismiss stage, legal fees can be tens of thousands of dollars. So imagine, you're in a situation where you've been harmed, you've come forward and spoken up about it because you thought that was an okay thing to do, and then somebody has abused you with a lawsuit, and now not only have you experienced that original harm, you're on the hook for tens of thousands of dollars that you probably don't have, plus, any other losses that you've suffered over the course of the lawsuit. So an anti-SLAPP law, a good anti-SLAPP law, will essentially make up for that. Unfortunately, anti-SLAPP laws really vary. So there's 19-ish states that have no anti-SLAPP law at all. So that is obviously horrifying. The rest of the states, they vary. As Professor Green said, I kind of broke this into 3 categories, but you have really good anti-SLAPP laws that that will recognize, any kind of statements that are statements of public interest that will award those legal fees. And then you have some anti-SLAPP laws that are just basically useless for survivors that will say, oh, it only counts if you were making an official government petition or if it was about an environmental issue. So they kind of fall in.
And so just for the class, New York falls into that category. New York has only statements about public officials, basically. And so, my practice has a lot of anti-SLAPP. I've never been able to invoke New York's anti-SLAPP law, despite the fact that this is one of my practice areas. I've just never been able to use the law.
And I think that's really interesting. Anti-SLAPP is one of those issues that doesn't quite fall on political lines like you would think it would. So I think I would just imagine that New York would have a good anti-SLAPP law. You don't.
Nope.
Two of the best anti-SLAPP laws in the country are Texas and California. Couldn't be politically two more different kind of spaces. So that's a really interesting aspect of it as well.
Do you have any thoughts on why that might be?
I really don't. I think I think it depends on lobbying and individual interests, and it kind of I think it very much depends on the environment that the law is built in.
So we've talked about how these laws work. What are the counter arguments? Are there any arguments against them that you find persuasive? Or I think one of the arguments that is always made against them is look, especially in the sexual assault SLAPP context, or in the defamation sexual assault lawsuit context. Some of these things are things that you can't expect somebody to prove on their own, right? How on earth do I prove that you really didn't believe I was a sexual predator? And shouldn't that person be entitled to a trial? Do you kind of find that or any other arguments persuasive, or what are your responses?
I mean, I think it's difficult, right? Everything we do in law is a balancing act between somebody's rights and somebody else's rights. And I think that strong anti-SLAPP laws, there may end up being a handful of cases where it's really difficult for somebody to prove a valid case. But the point is that your case doesn't just get thrown out, right? You always have an opportunity to fight your corner to prove your case. And it's just about shifting the burden. So while it might make it a little bit harder to prove your case, it doesn't make it impossible. And for that reason, I think it's fair. And especially when you consider the larger countervailing public interest, which is that we need to protect people to feel comfortable coming forward and speaking up when they experience sexual violence or gender-based harm. Because as we've kind of seen, as more people have come out and done so in the past several years, that's how we really get larger, broader systemic change and hold people accountable.
So there's a question in the chat, and I'm going to read it to everyone. Iman asks, is there a way to litigate the sexual abuse case before the defamation case to make sure the abused party doesn't go bankrupt? So I think, and I hope I'm getting this right, Iman is pointing out that theoretically, at least, the survivor could sue the abuser before the defamation case even happens. And theoretically, if they win that case, obviously they're not going to then turn around and be liable for defamation because they already proved facts in court. Why would that kind of, why would that have an impact, and would that change how you view or not change how you view the allocations of rights here?
So I think that's a really good question and a really good idea. I think that there are two kind of things that make it difficult. So the first is that obviously a lot of people who've experienced something like this don't want to subject themselves to the legal system, even if they're doing it as a plaintiff, even if they're doing it by choice. It's still going to be a really long traumatic process that will take several years. And the result isn't guaranteed. So even if you know what happened to you, again, those things can be very difficult to prove in court and even harder to prove in front of a jury. Juries are really unpredictable. So even if you have really good evidence, you might get one or two jurors who just, think they don't want to do this to somebody, blah, blah, whatever. So there's that aspect of it. The other aspect of it is that there could always be a countersuit. So that's a good reason to not bring a suit in the first place. And something that stops a lot of survivors for bringing these civil claims is a survivor might start to litigate a sexual abuse case, a tort generally of maybe assault or emotional distress against somebody who's harmed them. And then while that case is going on, that person can bring the cross claim, the abusive cross claim, holding them accountable for defamation. And so then if they lose, the stakes are they're going to be held accountable for defamation. So it's just kind of like a risky proposition.
So in one of my cases, and I'm actually not representing the person who did this, but it's a sex pest defamation case. And it was brought by the person who was the abuser. But after he brought the case, one of the people he sued turned around and sued him for sexual assault. And so kind of that maneuver works both directions. But I think at the end of the day, what Alyssa's pointed out is in terms of does this cure the bankruptcy problem? It really doesn't, because to bring the suit against the abuser in the first place is going to cost just as much as defending the suit, if not more. And it's going to incur, like, right, as soon as somebody lawyers up, the other person lawyers up, right? Like these things don't de-escalate by litigating them, they escalate. And the costs escalate for everyone. So from there, I think I had online a transcript from a hearing in a very high-profile anti-SLAPP case brought by an anime voice actor. I think it's fun to read this one because like the whole saga here is so absurd. And one of the things that I think it gives a window into is as you read that transcript, I had read it months ago and I read it again today to prep. It was very striking just how incompetent the lawyering was on the side of the abuser. And so I guess let's start with, I'll give some background on it, and then Alyssa, maybe you can comment on like what works and doesn't work about the anti-SLAPP law in place in Texas in this case.
Sure, yeah.
So the background here is the person who sued was an anime voice actor who has had a reputation in the industry for a very long time for being not necessarily, a sexual predator with a capital S and a capital P, but for being pretty creepy. And so like, there are, he even like in various public videos kind of makes jokes about that fact. But he also has like this public image as somebody who is moral and upstanding, or he thinks he does. And so it turns out that over a long period of time, he's been doing a lot of really creepy stuff. And at a certain point, about a year and a half ago, it had always been talked about in the community, but the community conversations boiled up and over online. And so, a tweet went viral, and ultimately he gets fired from one of the places that was employing him as a voice actor. His appearances at various anime conventions get canceled, and he has this internet shock jock raise about $350,000, right? Like $300,000 to fund the Vic Kicks Back campaign, which is designed to, as the title says, and I'm reducing a lot here, but that's fine, kick back, right? To kick back against the people who are accusing him of these things, and reestablish his good name. And so they find this lawyer in Texas, and they bring this lawsuit in Texas that has a very strong anti-SLAPP law. The claims kind of include claims against the employer, claims against some people who tweeted and retweeted some things, and kind of amount to a grab bag of all the possible torts, right? So that there is defamation in there, and that's probably the center of it, but they also allege some civil conspiracy claims and tortious interference with contract, which basically amounts to, I had this contract and it was gonna make me money, and then you screwed up that contract. And a couple other again, just like civil litigation grab bag. And after kind of a whole lot of lawyering, they end up at this hearing. And at the hearing, and then after the hearing, every single claim gets thrown out. And then a couple months later, the judge issued an order directing about $200,000 in legal fees to be paid to the people defending it. So that's the story, right? Alyssa, why don't you kind of take us through some of either just what struck you or how the anti-SLAPP law does and doesn't work here?
Sure. So as Professor Green mentioned, and we talked about a little bit before you all joined us, is what is shocking about this case is just like how poorly it's done by the plaintiff's attorneys. Every aspect of it, they've kind of messed up. They brought the case in a place with like the strongest anti-SLAPP statute when they didn't have to do that. They didn't plead things correctly. We could go on and on. But I think what was striking to me is even given that, so even given that this is the place with the strongest anti-SLAPP law and like the attorneys did such a bad job, this case still dragged on for several months for the women who were sued. And
it's still going, right? It's on appeal now. Right. And so, yeah, sorry, just wanted to flag, it's not over.
Right. Absolutely. And it will be upwards of a year, probably upwards of 2 years before this is resolved. And in the meantime, they've accrued hundreds of thousands of dollars in legal fees and will accrue more. So that's just something to think about. That's what happens when things work, when things go well. So imagine how bad it is when there's not an anti-SLAPP law or when things go poorly. But so specifically Texas's anti-SLAPP law and how it worked here. So Texas has a really great, strong anti-SLAPP law. The standard to which the plaintiff has to show things when they come into court is actually very high. I can't remember the exact words of the standard, but it's essentially clear and convincing.
It's clear and convincing, right? Yeah. And so as a baseline rule, in almost every case in the civil system, you have to prove preponderance of the evidence. And that's the word we use. It basically means more likely than not. And that's in contrast to, I'm sure you all know, the criminal system where what you have to prove is beyond a reasonable doubt. Right? So those are the two standards everyone knows. Somewhere between those two is this thing called clear and convincing evidence. It's used, for example, in a lot of contexts to prove fraud. But one of the things that the Texas law does is it bumps up the burden even at the beginning of the case to say you have to at least show clear and convincing evidence of each element of your claim if it's a claim about matters of public concern.
Right, exactly. And so that was one thing that was really at work to protect the survivors in this case, and it protects survivors in Texas generally. I don't think it was the law at the time that this case started being litigated, but I do know that in the last year, Texas has also updated their anti-SLAPP law so that sexual assault is always a matter of public concern. So anytime you're talking about sexual assault, you're going to be covered under the law. So that's great. Another great thing is that it is mandatory fees. So you have to, that's right? It's mandatory.
Yeah, the attorney's fees are mandatory. And there's also another, so sometimes fees aren't enough, right? Like attorney's fees just theoretically put the person in the same shoes they would have been in had the suit never been brought, but they have gone through the suit. And so one thing, it doesn't set a level that you have to do, but at least as the courts have interpreted Texas law, it requires not just attorney's fees that are the actual hours your attorneys have worked, but it also requires a penalty. It requires sanctions, although typically courts give very low sanctions numbers. And I think ultimately in this case, it was no more than like $10,000 between all of it, but it might have been a little more. But yes, there's also a sanctions component. Otherwise, yeah, that's exactly right.
Which is great. But of course, like as Professor Green mentioned, nobody's getting rich off of being sued for this sort of thing. There were, multiple defendants in this case, and $10,000 split between all of them is like nothing, especially given the time that they have devoted. The flip side of that, the one thing that I notice about Texas's law that is kind of a bummer is that it does do a lot. I mean, a bummer depending on who you ask. It does a lot to try to protect the person bringing the claim. And one of those things is that it allows a little bit of discovery to happen. So in this case, is that right? Because in this case, there were depositions.
So I think it's a weird thing because as I understand it, and I'm not an expert on Texas law, it's like many jurisdictions, when you bring your first motion, it suspends discovery. So right, like we talk about the motion to dismiss generally as being before discovery. There are some jurisdictions where that's not true, and you do them both at the same time. In Texas, the way this works is that basically the filing of your anti-SLAPP motion stops discovery. So what happened here is, for some reason, and this gets back to like, oh my God, these lawyers are so stupid, they let the plaintiff get deposed. And you know, they had to trade letting the survivors get deposed, which can suck. And like I have elected not to make that bargain in several of my cases. But what happened is they basically agreed to do limited discovery, then file the motion.
Okay.
And because they got that deposition, they got him to admit basically everything that was necessary to throw out the suit. Again,
bad lawyering.
Right, and I think perhaps, you know, the bigger picture thing that is interesting from this is there isn't, I think a lot of people think of our legal system as having filters before stuff happens, right? The idea being like, okay, so if somebody sued me, they have to have a claim, right? Like this has to be colorable. And it turns out that like months of lawyering and litigation and tens of thousands of dollars were expended on these depositions and on discovery and on all of this before, you know, the court essentially looked at this and said, this is garbage. And so I think one thing that I don't know the answer to is that, and I'm guilty of this very, very much. Like when I file a motion to dismiss, I don't like it to be incomplete because you only get one shot at it. And so like the fact that a court might toss out a suit on like the technical ground you're correct on doesn't mean you get to skip doing all the other work to see if the court does that. And so one thing that's very striking as you read this transcript is like, there's all this stuff where the court's like, oh no, I'm not like, no, that's done. And like, if you go look at the papers, there are like hundreds of pages about this. And the court just like looks at it and says, yeah, no dice. So in terms of what makes a good and a bad anti-SLAPP statute, you make some proposals in your paper. You want to walk us through some of those and perhaps like use them as a lens to that case?
Sure. I thought, before I start, I thought I heard somebody trying to break in with a question and just want to make sure that they have an opportunity.
Yeah.
Oh, yeah. I just had a quick question. Hi. My question was, I heard that you were describing the case where the lawyers did not do their best of job, I guess, in defense. In that situation, I mean, I see like two perspectives. One of the lawyer, how would they be able to protect themselves from like, let's say like a sort of revenge or something like that? You know what I mean? Because if I'm part of the defense or something, and then I hire a lawyer who literally was incompetent, as you guys like described, I mean, I would be very pissed off, you know what I mean? Like, I would be like, oh my God, especially if I had to file an appeal like these women had to do afterwards. I mean, that's more cost and everything, more hassle. That's just more of everything, you know, more trauma at that. So yeah,
let me do some cleanup on the facts there, and then Alyssa, I'll let you answer.
Yeah.
Just kind of to be clear, the bad lawyering was on behalf of the abuser, right? Like the comically bad lawyering is on behalf of the abuser. I think one of the like more notorious pieces of the case is in the initial like, if you don't like pay me money, I'm going to sue you demand letter. There was a claim that like somebody had said like Vic is a piece of shit. And then they said, that's defamation because my client is not literally feces, which, like, that's kind of like the funniest thing I've ever seen written. And I know I don't have a good sense of humor, but like, it's kind of funny, right?
No, totally.
So where we are right now is that this predator has filed a lawsuit, or I'm sorry, has filed an appeal, and he's allowed to do it, right? It's his right to appeal. So it's on appeal, but obviously everyone's still spending money on lawyers because you have to spend money to fight the appeal. If you don't oppose the appeal, then the decision's going to get reversed. But the decision did throughout the lawsuit. But I think that the core of the question is still absolutely interesting. So Alyssa, I'll let you take some of that, and then anything that you want to throw to me, you can throw to me.
Sure. So one thing I think, generally as an attorney, the way to prevent that is to take cases that you know that you have the background and experience and competence to do. And I think that this attorney stretched way far beyond what their background experience and competence was. And so I don't have a ton of sympathy for them. But generally that is something that attorneys think about and worry about. It's why they carry malpractice insurance, because their clients can turn around in some limited cases and sue them or file a complaint with the bar if their representation is actually so bad that it rises to the level of malpractice. I don't know enough to know whether the representation in this case would reach that. It's really, really bad representation, but I couldn't say beyond that.
Right. And it's in this case, it's very hard to separate the kind of comically bad lawyering from the comically bad desire to file a complaint over this.
True.
Right. These facts aren't defamation. So it is certainly true that the lawyering could have been better, but that doesn't really address the ultimate question, which would be the question in a malpractice case of whether they actually harmed him, because you would also have to show that this claim that he wanted to bring had some merit, and the acts of the lawyers in being incompetent lost him that claim that he otherwise would have at least had a chance of winning.
Okay. Yeah, that's what I was thinking, because if I had gotten the facts mixed up, but in general, I would think that especially if the okay, let's say this goes let's say if a case were to go to and presents itself to a trial, and a jury, then let's say I remember I think Alyssa had mentioned that even if you could always present your case, you know what I mean? But the results are never 100%, you know what I mean? That you never know if they're gonna actually be found, guilty of the sexual abuse and things like that. So in that situation, I mean, what would even the person who's whether it be the abuser or the victim, I mean, what would they do in that situation? What's the next steps? Let's say, okay, I presented my story, but they don't believe me. Is it just that, or can I file for more, I don't know if it has to be in a I don't know if you have to reopen the case and then see if you could do another discovery or something like that, and see if you could collect more evidence or something in that situation. But what would you do if they don't believe you? That would, I think, would be my fear if I were a victim of sexual abuse, okay, I present my story, but there's never 100% that they're going to believe me, or that the results are going to be what I at least deem to be just, in the situation.
Alyssa?
Yeah, that's a big question. That question is kind of my life's work because it's tough, right? There's not much you can do. And in these situations, that's a survivor's worst fear, is that they are going to be found responsible for defamation when they're not lying, and they're going to owe this abuser money. And they're going to have this mark on their record of having lied about something that they didn't lie about. And you can appeal certainly any outcome in limited cases, but it's especially for a case that went all the way to a jury, it's very hard to win an appeal at that point. So it's tough. Yeah, I mean, the system can be really harmful in that way.
Oh,
To
okay.
build on what Alyssa's saying, I think that one of the core points of her paper is that theoretically, at least, the law of defamation places the burden on the plaintiff. But as you, Kelly, identified correctly, there's kind of this popular conception that the real question is, do you believe her when she tells her story?
Yeah.
And theoretically, that's not actually what should be happening in a defamation case, right? What should be happening is not, do you believe her, but do you believe that she believes herself?
Yeah.
And more than that, has the plaintiff shown that she didn't believe herself, right? So that the focus should be different. But it is certainly true that in every one of these cases, the people who bring them try to shift that so that it's basically, no, it's your burden to criminally prosecute my client who brought this lawsuit. And that misapplication of the law happens every day. And so one of the functions, I think, that Alyssa points out in the paper of an anti-SLAPP law is to even though it's kind of already the law, is to shift to an earlier stage, the put up or shut up moment for the plaintiff, and really make it a, look, this is your burden. The judge should not have to go search through volumes of court reported cases, of case reporters to find the fact that it's your burden. No, the law just says right there, the plaintiff has to show actual evidence that is clear and specific that, among other things, this person did not believe it was true that you did X, Y, Z. And that's where, when you have the anti-SLAPP laws and they're applied correctly, these cases fall apart for the most part, because that is a very hard thing to show. And that, I think in some ways that's the goal. We have about 10 minutes left for what we've prepped, and we've transitioned a little bit, but I'd like to just make it explicit because some people tend not to ask questions. I'm reminded that at the Supreme Court right now, after years of not asking a single question except on every 6 or 7 years, now that when he has an explicit turn, Judge Thomas has asked a question at virtually every oral argument. So I am going to explicitly say, okay, we're open for questions. Let's try not to talk over each other. If you have a question you want me to read instead, especially because we're recording, please just put it in the chat and I'll read it. Otherwise, feel free to jump in to ask Alyssa and I questions, and we'll try to, I think, tag team them a little bit. I assume some people are possibly typing, but we can wait to be interrupted too. So any final thoughts? Is there anything we've glossed over, Alyssa, that you want to say?
Well, it's so hard. There's so much to say. I'm trying to narrow down a few important items. One thing that I will say that I have kind of learned in interacting with these cases that's really difficult is that it is very hard for a survivor in this situation to find somebody to represent them. Oftentimes because they don't have the money to pay up front, and the legal services organizations that usually will represent somebody if they need to go to court for a restraining order or something like that, they don't have this highly specialized background to do that. And some of them are not allowed because of the grants. They have to work on civil cases like this. And so it is extremely important that, as we're talking about this issue, we also talk about finding a way to expand availability of services for this sort of thing.
Professor Green, I have a question.
Yeah.
And thank you for giving us this speech, Alyssa. So my question is, how did these anti-SLAPP laws come to impede the First Amendment and especially the freedom of speech? How did they come to existence, and how did sort of the court prove, or the initial case, I guess, that gave birth to these anti-SLAPP laws? How did they prove that they impede on First Amendment freedom of speech?
Sure.
Alyssa, go for it.
Okay, so I don't know maybe as many specifics as you're looking for, but I can tell you that they largely started with environmental activism and environmental concerns. So there were a lot of environmental activists who were hosting these large-scale protests. And a protest is something that's protected by the First Amendment as well as speech. And their protests might, limit developers and people who are chopping down forests. I'm just like using broad examples because I don't know the specifics from doing their business. And so they would want to interrupt these protests. And so they would sue folks for engaging in these protests. And these folks said, hey, actually, this is our right. And if this case were to go all the way, you wouldn't win because we have a right to do these protests. But that's not what you care about. You care about stopping us from doing protests because we don't have the money to defend the cases. You're just trying to scare us. And so that was kind of the context in which, as far as I'm aware, that's the context in which this first arose. And then folks started to realize that it was happening, much more broadly than that context.
And to pick up, I think, on one of the other points that you just mentioned, Iman, you are right that there are two First Amendment rights implicated here, or two people with First Amendment rights. There's far more than just two individual theories of First Amendment right. There's the right of the person who has spoken up to speak, but there's also, I think you're right to point out, a First Amendment right of the person who's filed the lawsuit to not be deprived of things without process, and a right of access to the courts. And one of the challenges that these anti-SLAPP laws face on constitutional grounds is whether this is an undue restriction of right of access to the courts. So certainly, I think a law that just said you can't bring defamation cases, maybe not, but I think there would be some constitutional issues with it. On the other hand, I think that the response from the anti-SLAPP community, and I personally agree with it, is that this isn't really taking away a right so much as saying, we're going to like reshape the process of an ordinary lawsuit to better accommodate this other First Amendment right that we think is very important, right? The right to speak. So that if you're gonna bring one of these defamation cases or one of these tortious interference cases about environmental protest, at the end of the day, what you're gonna have to do is you're gonna have to show us why you think you win at a much earlier stage when the other person hasn't expended as much money. That, I think, is not inherently unconstitutional. There was another thread in there that I wanted to pick up on in what I think Alyssa was saying just before Iman asked a question, which was, so one thing that we've done in this country for a long time, and one of my other big practice areas is what's called 1983 litigation, which is about constitutional rights against, say, the government, is that we have these things called private attorney general statutes, which, like the anti-SLAPP statutes, provide attorney's fees for people who take certain cases. And it is true that in these anti-SLAPP jurisdictions, there are people who will take, who didn't exist before, who will take cases for free. And not really for free, because they'll sign a retainer, but what they'll say is basically, you're agreeing to pay me this much an hour during the case, but I'm gonna waive that, and instead I'm just gonna go after the other person for that money. And the structure of these statutes, in part, is, I think, designed to address this thing that Alyssa identified as being really, really hard, right? In New York, it turns out it's really hard to find somebody who's willing to defend a defamation case. In Texas and Tennessee, it's a lot easier because these attorneys know they're going to win these cases because they're garbage. But then once they win them, especially because these are very frequently bought by people who can afford attorneys to harass people, that they're going to be able to turn around and collect their attorney's fees from that person. And so it turns out that there are two effects. One, it discourages the suit in the first place, but it also encourages representation. I think we're getting towards the end of the time we have, so if anyone else has a question, now's the time.
I actually have one more question, sorry.
Yeah, no, go for it.
So I'm also taking a criminal law, a crime and punishment class with Professor Evans this semester, and we speak a lot about sexual abuse cases and on the criminal side of it. So my question was, if the abused party sues the abuser, well, there are obviously many things that they could sue them on. One would be, obviously the battery side of it, and then there could be emotional distress. And my question was, when these cases go to court, does the abuser get prosecuted criminally, or just for like it causing emotional distress? Because that would be a private case.
Well, Alyssa, you're gonna either take or wave out of the bar very soon. So, you want to give the bar exam answer?
Sure. So sometimes, but not always. They're two totally separate systems. So just because you bring a civil claim doesn't mean that there's going to be a criminal claim. And as you probably know from your criminal law class, you have to reach that, beyond a reasonable doubt standard, which is this standard that's up here. Very different from the civil standard, which is preponderance of the evidence. So just because you win a civil suit, it's not enough. That person isn't also going to jail. You would have to go through both processes. And just the same, because the civil suit doesn't offer the sorts of money damages, or the criminal case doesn't offer the sorts of money damages that a civil suit does. Even if you win a criminal case, or even if that person goes to jail for sexual abuse, you're not going to be awarded money unless you bring a separate civil case. At that point, your civil case is going to be a lot easier, but it's still a separate process.
So with that, I'm going to give Alyssa the last word, and then I'm going to stop recording and just say goodbye to everybody. So Alyssa, anything else you want us to remember other than, go read Alyssa's paper. It's really good. It's really, really good.
I appreciate that. It's really, fantastic to hear that from somebody that I admire so much. But no final words really, except to say that, I appreciate all of you for indulging me while I talk about what is really a niche, nerdy issue that I care about a lot, and that I've gotten to connect with Professor Green on. But congratulations on surviving just the really hellish semester, and I hope that you're all taking care, and that the world returns to a little bit more normal for all of you soon.
I couldn't say it better. So with that, I'm gonna end the recording. So thank you, Alyssa. This has been such a delight, and I'm so grateful that you were able to make the time. So thank you, and thank you, everyone.